Hi everyone, and welcome to the video lecture, Juvenile Probation and Parole. In this lecture, we'll discuss the development of the juvenile community supervision system, and we'll also highlight some of the important court cases that have shaped the juvenile system and supervision practices. When you talk about the juvenile probation and parole system, it's important to realize that the reason that the juvenile justice system was designed for. In early colonial times, children were treated the same as an adult. If a 12 or 13-year-old committed a crime, they would be incarcerated just like an adult would. They were treated just like adults with no consideration for their age. Now, there was no formal juvenile justice system at this time, but there were facilities in place for juveniles that were in need of supervision. Parens patriae is Latin for parent of his or her country. This concept means that the government or the state has the duty of serving as a guardian for all of its citizens. As part of that role, the state must ensure that children within the state who are not legally able to supervise themselves are supervised and parented properly by an adult. Under the parens patriae doctrine, if the parents cannot serve as an effective guardian for the child, it becomes the state's responsibility to step in and help the parent the child instead. Reform schools and orphanages were the result of this type of system. Both were designed specifically for juveniles, with reform schools used for juveniles accused of minor crimes and homeless children, and orphan asylums used for abandoned and orphaned children. The problem was that these were really corrupt institutions. There wasn't a lot of oversight, and there was no required rehabilitation programming, so adults in charge of these facilities were allowed to distribute the money how they wanted, even if it was in their pockets. As a result, the reform schools in particular experienced very high levels of violence, and children sentenced to these facilities had little chance of being successfully rehabilitated. Children convicted of more serious crimes were also still being incarcerated with adults, so the system was far from perfect. In the late 1800s, early 1900s, a child-saving movement arose where society started addressing the causes of criminality rather than just the actions themselves. In particular, the child-saving movement believed that in order to reduce crime, we needed to stop the cycles of poverty that our children were living in. The juvenile court system was one of the outcomes of this movement. By creating a separate court system and separate process for juveniles, the hope was that juveniles could be reformed out of the cycle of poverty and therefore reduce crime. The first juvenile court was created in Illinois in 1899. This court served as a place not just for children who were in trouble, but also for children who were in need of supervision and adult assistance. The 4 types of cases supervised by the juvenile court are delinquency cases, status offenses, neglect and abuse cases, and dependency cases. Delinquency cases are for children who are accused of behaviors that are criminal even for adults, things like shoplifting, theft, assault, etc. The same kinds of offenses as adult courts, but in juvenile court we would handle them differently. Status offenses are criminal behaviors that are specific to children. The only way you can be charged with a status offense is if you're a juvenile. That's why they call it a status offense, because it's inherent upon the status of being a child. Examples of status offenses include school truancy, running away from home, underage drinking, that type of thing. Crimes that adults can't be charged with, but are considered criminal behavior for juveniles. The other 2 types of cases involve juveniles who haven't committed any crime, status, or otherwise. The reason that these juveniles are included in the juvenile court comes back to the parens patriae concept. If the parent is not or cannot parent successfully, then the state is obligated to step in and parent the children for them. Neglect and abuse cases involve guardians that are not parent appropriately, whereas dependency cases are those juveniles who lack a guardian entirely. Both of these situations will result in a child entering the juvenile justice system, but it's not meant as a criminal sanction. What really distinguishes the juvenile justice system from the adult system is the outcome of the process itself. In juvenile courts, the court is seeking to supervise and reform, not just punish and incarcerate. Remember that the juvenile court comes from the child-saving movement, so the whole point was to make the juvenile courts distinct from those of the adult courts. Juvenile courts, as a result, were designed to emphasize the reformation and the rehabilitation process very strongly. And so the juvenile court system uses completely different terminology than the adult system. This was done on purpose to emphasize the difference between the juvenile courts and the adult system in terms of punishment and control. The chart on this slide shows some of the vocabulary differences between the two court systems. In a juvenile system, a charge is called a petition. Trials are called adjudicatory hearings. If a child is found to have committed the accused behavior, the courts call that an adjudication instead of being found guilty. Sentences assigned to those adjudicated delinquent are called the case dispositions, and incarceration is simply detention. Parole is considered aftercare. Notice the emphasis on the reform and the social work aspect in these terms. There's a reduced emphasis on the offender image and a stronger emphasis on reformation and rehabilitation. Instead of charging someone with a crime, someone's going to petition the court to look into a criminal act or a guardianship situation. Aftercare suggests that the juvenile is being provided with services and support, not just supervision post-release. So the same steps as an adult system for the most part, but with different names and different emphases. Let's talk a little bit about the process that a juvenile offender goes through from the juvenile justice system onto a parole or probation supervision sentence. The juvenile court process will start with either an arrest or referral of the juvenile. A referral can come from a variety of sources, and these are used when a community member or law enforcement officer has concerns about a juvenile situation or behavior. So, for example, a school can refer a student as a suspected neglect case or as a behavioral concern. So juveniles don't need to be arrested in order to enter the justice system, which provides for the entry of the non-criminal cases into the system. After the juvenile has been arrested or referred, they're going to go through an intake hearing. This is usually conducted by a probation officer, and it's very similar to the PSI interviews that you learned about previously. The point of this hearing is to allow a neutral third party to determine how severe the case is and what the next step should be. This next step is probably one of the biggest differences between the juvenile and the adult justice system. Historically, we have emphasized the informality of juvenile court because the goal is giving the juvenile the best treatment and support as opposed to formally labeling and charging them. As a result, during this intake hearing, you're still not formally in the juvenile justice system. In fact, one of the options that an intake officer has is to release the juvenile so that they don't formally enter the system at all. For example, if faced with a juvenile committing relatively minor offenses or maybe on their very first offense, the officer may decide that sitting down with the parents and the child in a family conference will be the most effective to control the behavior at this time. So the juvenile remains out of the juvenile justice system formally, but is given a warning that repeated instances will result in more severe punishment. The supervision officer can also choose from a variety of diversion options, which are used when the officer believes that the issue cannot be addressed with simple conferencing, but believes also that the behavior is not severe enough to warrant admittance into the formal system. The hearing officer can assign the juvenile to diversion sentences like community service or teen court, in which the juvenile is required to complete in order to remain out of the justice system. Hearing officers can also refer directly to probation. In the adult court, probation is used solely for convicted offenders. But in the juvenile justice system, the offender can be placed on probation without going through a full trial. This is done to avoid the formality of a formal petition and adjudication. Similar to the judicial reprieve situation that was used in early probation, the juvenile avoids formal charges so long as they complete a period of probationary supervision successfully. In keeping with the reformation emphasis, this probationary sentence will often include rehabilitation services, like mandatory counseling, education requirements, etc., with the goal of reducing repeat behaviors. Now, in cases where the behavior or the juvenile's history is severe enough to warrant formal intervention, then the hearing officer can petition the court to actually hear the cases. In rare cases where there's concern about the age of the offender or the severity of the offense, the hearing officer can also request that the case be sent straight to the adult court. If a juvenile is actually referred to the juvenile justice system, then they're going to have an adjudicatory hearing. Remember that that's going to be very similar to a trial, which is why I've got that in quotation marks here on the slide. Adjudicatory hearings have different burdens of proof depending on what type of case is being decided. Delinquency cases, or cases where the juveniles are charged with a crime that an adult could be charged with, are held to the same burden of proof as the adult court, meaning beyond a reasonable doubt. Status offenses are a little different. Status offenses require only preponderance of evidence, as do neglect, abuse, and dependency cases. Compared to the 99.9% certainty that's implied by the words beyond a reasonable doubt, preponderance of evidence is simply a majority. So if you are 51% thinking this is true, that's it. The reason for this comes back to the parens patriae concept. If we're concerned about the juvenile's behavior or their supervision, then we're willing to step in earlier to provide services for the juvenile and the family if possible. The state doesn't want to make it overly difficult to identify problematic cases where they need to step in. So the preponderance of evidence allows, if it's more likely than not that this situation exists or that the juvenile is engaging in this type of behavior, the state has the ability to step in. On the previous slide, I mentioned that juvenile courts were designed to have a high degree of informality. Now, that's something that we see beginning to change over time, especially in the middle to late 1900s. One of the reasonings for the increase in formality was a concern that the informality may actually be making things worse for the juvenile. One of the most famous cases relating to the juvenile justice system is In re Galt case from 1967. Galt was a juvenile male that was accused of making obscene telephone calls to his neighbor. This was a delinquency case because he was charged with making lewd phone calls, which is something that an adult can also be charged with. Now, Galt was already on probation at the time he was accused of the phone calls, so he was arrested and taken to the detention home immediately. However, both of Galt's parents were at work at the time, and the arresting officer didn't leave any notice for them about the situation. Galt's parents only learned of his arrest from a family friend later on in the day. The same day that Galt was arrested, the officer filed a petition with the juvenile court, and Galt was given a court hearing a few months later. Now, Galt and his parents were told about the hearings, but they weren't given any information about the petition itself. They didn't know what the specifics of what he was being charged with, they didn't know what the evidence was against Galt, etc. In total, Galt went through 2 hearings without his parents present, even though his mother specifically requested to be included in the second hearing after she found out the first one took place without her being there. In keeping with the informal nature of the juvenile court, Galt's hearings weren't transcribed or recorded, and witnesses were never sworn in. The court process was essentially an informal conversation between the lawyers, Galt, and the judge, and there's no record of what actually occurred during the proceedings. At the conclusion of the second hearing, Galt was adjudicated delinquent, meaning he was found guilty. The judge committed Galt to a juvenile detention facility until he was 21, which was 6 years away. Now, Galt's parents appealed his sentence based on several concerns. The maximum punishment for an adult convicted of making obscene phone calls was a $50 fine and 2 months in jail. Galt got 6 years in detention for the same crime, so there were concerns about the sentence disparity. Galt's parents also raised concerns about the trial process. There were conflicting reports about whether it was actually Galt doing the calls or whether it was a friend of his, and there were questions about what Galt actually admitted to in front of the judge. The problem was that no records were kept of the original trial, so they couldn't just look in the transcript as to what was said. Galt's parents ended up appealing the ruling of his detention all the way to the Supreme Court, and the Supreme Court justices sided with Galt's parents. The Supreme Court ruled that the juvenile should be afforded the same due process rights as an adult. Now, this was huge because it seemed to go against the very concept of an informal, rehabilitation-focused juvenile justice system. People were concerned that giving juveniles due process would create a more formalized adversarial system, much like the adult system, which basically would defeat the whole purpose of a separate juvenile justice system. However, the justices ruled that Galt's due process rights were really important because the informality of the system prohibited any checks being applied to the process, because the appellate court had no way of knowing what was done during the original hearing and trial. In particular, the Galt decision gave juveniles 5 due process protections. First, juveniles had the right to receive written notification of the charges against them. This way, the parents would be informed about the charges and what evidence was used. Second, juveniles had the right to counsel. Just like the adult court, juveniles who could not afford an attorney would be provided one for free. Third, juveniles have the right to be protected from self-incrimination. And what this really comes down to is that witnesses have to be sworn in. Galt wasn't informed of his constitutional right not to incriminate himself, So the court ruled that juveniles would have to be notified about their right against self-incrimination. Fourth, juveniles have the right to confront and cross-examine witnesses just like adults do. Finally, juveniles have the ability to written transcripts and appellate review of all hearings. It's very difficult to appeal a decision without a written record, because how do you appeal something that you can't prove actually occurred? In fact, in most cases, an appeal without a transcript means that the whole trial had to be done over if there were concerns about the original trial. As a result of the Galt case, though, juvenile court proceedings had to be recorded in some manner so that the juvenile could have access to a written transcript upon request. One of the constitutional rights that the Supreme Court did not extend to juvenile courts was trial by jury. This omission would later be reaffirmed during the McKeever v. Pennsylvania case. The McKeever decision involved two juveniles that were adjudicated guilty of robbery, theft, assault, and escape by a judge. Both juveniles had requested a jury trial, but they were denied by the trial judge. The Supreme Court upheld the conviction, finding that jury trials were not constitutionally required for juvenile trial court. The court said that the rights afforded in the Galt decision were designed to ensure accurate fact-finding during the trial itself, but having a bench trial does not hinder fact-finding. Additionally, the court noted that juvenile prosecution is not considered either civil or criminal, so the Sixth Amendment did not necessarily apply. As a result, there is no constitutional right to a jury trial in the juvenile justice system. That being said, the Supreme Court didn't prohibit jury trials for juveniles, and many states use jury trials in their juvenile justice systems anyway. In Texas, juveniles have the right to a jury trial if they're charged with certain offenses. So it is used in our system, but it's not required for all juvenile offenses. So let's say an offender is adjudicated delinquent. Now the judge will determine the appropriate disposition. Because of the rehabilitation focus, the goal is to use the least restrictive environment necessary and to help facilitate the rehabilitation of the juvenile. Juvenile court judges have the ability to sentence juveniles to a variety of different dispositions. One of the most common is probation supervision, and that probation supervision will work just like adult probation. The juvenile is sentenced to a specific time on supervision, and like adult supervision, juvenile probation may include conditions like GPS monitoring, counseling sessions, substance abuse treatment, etc. Juvenile court judges also have several alternatives that are more restrictive than community supervision, but not actual detention facilities. The courts can send the child to a boarding facility, a group home, or a military academy. And these are normally reserved for situations where the removal from the home itself is deemed as appropriate, like when the home environment is unstable or when the parents are unable to supervise the juvenile successfully. Another possibility, and one you may not have heard before, is something called teen court. This is a program most utilized in school districts for juveniles accused of misdemeanor crimes. In teen court, teenagers serve as both the jury and the lawyers. So juveniles are literally sentenced by a jury of their peers. Teen court emphasizes rehabilitation punishments, so they do a lot of things like community service and academic requirements. For instance, a juvenile accused of graffitiing the schoolyard may be required to clean up the graffiti as part of their sentence, and they may also be required to write a paper about their experience. Teen courts are also used as diversion programs, so juveniles can be sent to teen courts before they enter the juvenile justice system formally as well. Now, if necessary, judges do have the option of sending the juvenile to a juvenile detention facility. Remember that detention is the same concept as a prison or jail sentence for adults, so this is the most restrictive disposition possible. Something that's different between the adult and the juvenile courts is that while adult courts usually focus on the offender by themselves, most of the dispositions in the juvenile justice system include both the juvenile and their family members in some way. This is the result of the parenting focus. Again, if the court believes that part of the behavioral problem stems from family-related issues, the court may require that the parents themselves be involved in the disposition so as to rehabilitate the entire family unit. Probation officers will often touch base with parents throughout the supervision process, and they may offer family services like family counseling and welfare assistance in order to help the parents support their child better. Another difference that we don't see is we don't see financial restitution used as much in juvenile courts like we do in adult courts. Restitution with juveniles is a bit difficult because when judges sentence juveniles to pay a financial penalty for an offense, the parents are the ones that end up paying the money. So community service is usually preferred in most cases to a financial penalty because then the offender themselves has to be involved in the restitution process. Just like the adult system, the disposition is designed to be the least restrictive possible. However, the juvenile can be sentenced to additional, more restrictive conditions if they don't fulfill the requirements of their original sentence. Violations like fighting, missing curfew, or even not behaving at home can result in additional sanctions like more intensive supervision, an extended supervision time period, or removal from the home. Now, as I mentioned previously, the rehabilitation emphasis in the juvenile justice system has shifted somewhat over the past several decades. We see an increase in punitiveness of the juvenile justice system, particularly for juveniles accused of more serious crimes. Although the juvenile justice system was designed to take all children out of the adult court, the juvenile court can transfer a case into the adult system under certain conditions. Most often, this is the result of an older juvenile being accused of a more serious crime. For example, the suspect in the most recent Colorado school shooting, Alec McKinney, will be charged in adult court even though he is only 16 years old. The process of sending a juvenile to adult court is called a waiver. Supreme Court decisions in Kent v. United States and Breed v. Jones both pertain to the waiver process. The first case came about in 1966 as a result of the conviction of 16-year-old Morris Kent. Kent was accused of robbing and raping a woman in her apartment. Kent had a history of delinquent activity, and he had been under supervision for the 2 years prior to the assault. With his history and the heinousness of the crime, the juvenile court judge felt justice would be better served if Morris was tried as an adult in criminal court rather than as a delinquent in juvenile court. Morris's mother hired a lawyer to represent him. The lawyer attempted to interview the juvenile court's social service director, the person who had been responsible for the court supervision of Morris during the previous 2 years. But Morris's lawyer was denied access to his client's social service file. Morris's lawyer requested the judge to grant him access to the file and asked the juvenile court to retain jurisdiction over Morris's case in order to maintain the same course of treatment and rehab that he'd been on for the last 2 years. Morris's lawyer assumed that there would be a hearing on his motion with a full opportunity to argue his side of the facts before the judge, but the judge never held any hearing. In fact, he made no ruling whatsoever on any of the motions and no finding of fact. Instead, the juvenile court judge simply entered an order that waived the prosecution of Morris Kent from juvenile court and asked that he be tried by the U.S. District Court in D.C. A jury found Kent guilty and sentenced him to serve 30 to 90 years in prison as a result of that conviction. Now, Morris appealed the decision all the way to the Supreme Court, noting that the judge had not investigated Morris's case before approving the waiver to adult court. The Supreme Court ended up overturning the original waiver. The justices ruled that because juvenile court afforded children special protections that were not afforded to adults, the decision to transfer a child to adult court is a question of critical importance. As such, the Supreme Court ruled that juveniles have a right to a formal hearing before having their cases transferred to an adult court. And they said that the formal hearing must measure up to the essentials of due process and fair treatment. The second case that impacted juvenile court waivers was Breed v. Jones, which came about several years later in 1975. A juvenile court found 17-year-old Gary Jones guilty of acts that would constitute robbery if he were tried as an adult. After the hearing, the court determined that Jones should be prosecuted as an adult. Jones' adult trial ended up with him being convicted of robbery in the first degree. Now, Jones appealed his ruling, arguing that his second conviction amounted to double jeopardy. The lower courts ruled that the verdict in juvenile court was not the same as the adult court verdict, but the Supreme Court disagreed. In a unanimous verdict, the justices ruled that once a juvenile was adjudicated in the juvenile justice system, the juvenile could not then be tried again for the same offense in adult court. The court suggested that in the future, juvenile courts make determinations about whether to try a juvenile as an adult at a preliminary hearing before any adjudication is made. This would help avoid any double jeopardy and allow juveniles to still be tried as adults when appropriate. Now, the last thing I want to discuss about the juvenile justice system are some of the challenges that we're currently facing in juvenile justice. The juvenile justice system has a very high recidivism rate, and there's a strong community push to start mirroring the juvenile justice system to be more like the adult criminal justice system. This would mean a stronger emphasis on punishment, more restrictive measures, and a more formalized process. Another challenge is what is known as the school-to-prison pipeline. At the same time that we see an increase in formality in the juvenile justice system, we also see an increase in law enforcement involvement in schools. Some criminologists argue that the involvement of school resource officers in secondary schools has resulted in the reclassification of juvenile misbehavior into criminal misbehavior. So the juvenile system has a lot more juveniles entering as a result of their school behavior. For example, there have been cases of juvenile court referrals for behaviors like chewing gum in class, being tardy, arguing with your teachers, etc. These are things that are definitely disruptive in the school environment, but they're less definitively criminal or delinquent behavior. The graph on this slide shows the arrest rate for schools with school resource officers versus schools without school resource officers. The overall arrest rate for those schools with officers present is almost 5 times higher than those without officers, even when controlling for school environment and social conditions. The lack of other support staff beyond law enforcement officers is also of concern. For example, the statistics on this slide indicate that many schools may have law enforcement officers present, but lack appropriate social service providers like counselors, nurses, and social workers. Additionally, the spread of zero tolerance policies, which require formal intervention for any behaviors regardless of context, have also played a part in increasing the number of juvenile justice referrals. Not only does the school-to-prison pipeline increase the entry rates of juveniles into the justice system, researchers have also shown that this pipeline has a more significant impact on lower income and minority communities compared to higher income school districts. This results in the increased referrals disproportionately affecting minority youth. According to the data compiled by the ACLU, Black girls in Texas were 5 times more likely to be arrested in school than white girls. This graph comes from research done on the Texas juvenile courts from 2011. In the accompanying article, Supreme Court Justice Wallace Jefferson notes that even though African American students only accounted for 14% of the Texas public school population in 2008, they accounted for 33% of the out-of-school suspensions in the same year and 25% of all expulsions. On the other hand, white students accounted for 35% of the total public school Texas population, but they only accounted for 18% of out-of-school suspensions and only 21% of total suspensions. Although some suspensions for some offenses are mandated by state law, like if you bring a firearm onto campus, it's an automatic suspension, Justice Jefferson points out that 97% of disciplinary actions are discretionary, meaning that it's up to the campus administrators to determine what the appropriate penalty is for the offense. Although minority students were removed from school at the same rates as white students for the mandatory arrests, Justice Jefferson found that minority students were disciplined for discretionary violations and referred to the juvenile justice system at alarmingly disproportionate rates compared to white students. For those of you interested in learning more about the school-to-prison pipeline, I provided you with several supplementary materials on Canvas. I encourage you to check these out. We also have some juvenile justice related courses here at UT Tyler, and I encourage you to look into those if that's something that you're interested in learning about more. All right, well, this concludes the Juvenile Probation and Parole video lecture. Thanks for watching.